legal proceedings were meant for securing the conviction and punishment of criminals. So they started with criminal prosecution. Many forms of prosecution existed. Indeed, depending on the nature of the prosecuted crime, the source of prosecution, which could be either private or public, would change. Thus, the pursued goals and the forms of the procedure would change. So, private prosecution was the dominant form in England before the 12th century. The victim, or his kin in homicides, could make an accusation of crime against its perpetrator. This procedure was called appeal. It started formally with the hue and cry raised by the victim. Once the crime notified to the royal officials, the appellant had to begin suit in person at the next county court. Then, summoned, the appellee had to show up at the court under penalty of being outlawed and had to be attached. That is to say, he was required to find sureties ensuring that he will appear for trial. So the presumption behind the appeal was that some criminal conduct could affect individually private persons in particular ways. In the case, for instance, of homicides said simple, that is to say, death by misadventure or homicide committed without dissimulation. Appeal could end litigation through the payment of a compensation, a boat or a verdict in the case of homicide. It was the way to repair the wrong of the victim and therefore to avoid vengeance.
Yeah. The ecclesiastical jurisdiction has a similar kind of proceeding, although they didn't deal with violent crimes in the same way. But they had civil cases, of course, in which the plaintiff sought damages for recovery of property, things like that, and then criminal cases where the object was punishment against some offense of the public order. And these were things like marriage cases, violence against clerks, defamation, issues like that. And procedure in Roman law and consequently canon law differed ever so slightly between civil and criminal cases. In Roman law, the primary difference between the two was the nature of the sentence. So there was a little bit of difference in the start of the trial as well. Not everyone who could bring a civil case could bring a criminal case. And in criminal cases, the accuser was responsible for proving his case. And then if he could not, this is the thing with the sentence here, if he could not prove the case, he was to undergo the same punishment as the accused would have received. But canon law doesn't quite stick to that. That's really more of a Roman way of dealing with things. Gratian actually doesn't distinguish at all in the decretum between civil and criminal procedure, but the canonists that followed him kind of attempted to make a distinction between the two, with civil cases following Roman procedure more closely, and criminal cases following procedure modified by the canons. Tancred of Bologna, William Durantus, others devoted titles to criminal procedure in their treatises, and William of Drogheda, he promised to do so in his treatise, but this was one of the many he never managed to write. Despite the devotion of titles to criminal procedure, though, there was actually, as I said, very little difference, and the main issue was how you would punish somebody following a sentence. A criminal proceeding then could be instigated by accusatorial procedure, as you said, or by inquisitorial procedure. So that is either with an accusation brought by an individual or with inquests initiated by a judge ex officio, that is by virtue of his office. I think this is very similar to presentment procedure in common law.
Yes. Actually, from the 10th century in England, there may have been some forms of public prosecution as well. Indeed, some crimes were not considered to affect individuals only. They were seen as a matter of public concern because they were considered to be a crime against community. In this category, we found murder, theft, rape, and assault, for instance. And because of this public nature, a public official could initiate a criminal prosecution. Then, in the late 12th century, public prosecution was generalized in England. Indeed, under the Assize of Clarendon in 1166, jury had to present, that is to say, to report, all individuals publicly suspected of having committed a crime of murder, robbery, or theft to the sheriff's court and then to the heir justices. This was called presentment. And this procedure enabled some crimes to be prosecuted even if the victim did not appeal. And we also observe that at the end of the 12th century, a routine judicial practice to put on trial appellees when the prosecution was dropped by appellers. Thus, the nature of prosecution changed in the late 12th century. Presentment would become the predominant form of prosecution.